Good evening, sir. Do you know the reason I stopped you tonight?
You see it on body cam footage all the time. An officer walks a drug dog around a car. The dog sits. And suddenly, the entire situation changes. What do you do in that moment? What do you say? By the end of this video, you'll know the exact words that can protect you, and you'll understand the one timing trick officers use that most people completely miss. A trick that turns a simple traffic stop into a full-blown vehicle search. But before I give you that phrase, let me show you a case that ended very differently than the driver expected. The dash cam tells the story. It's a little after 11 p.m. on a Tuesday. A sedan is pulled onto the shoulder of a county road, blue lights strobing across the asphalt. The officer has already run the license, written a warning for a burned-out tag light, and handed it back. At that point, the traffic stop is over. Most people think the stop is still going, but legally, the reason for the stop is complete. And yet, the officer doesn't walk away. He leans back toward the window and says, "Hang tight just a minute. I'm going to have my partner run his dog around your car." Now, the dashcam timestamp tells us something critical. From the moment that warning was issued to the moment the K9 unit arrived, 12 minutes passed. That 12 minutes made all the difference, because when the dog finally walked around that sedan and sat next to the driver's door, the entire search that followed was later thrown out. The drugs found under the seat? Inadmissible. The paraphernalia in the center console? Suppressed. The charges? Dismissed. And the reason it all fell apart is something you can use to protect yourself, starting with the one phrase I'll give you in a moment. Let me rewind and break down exactly what happened, and why a judge looked at this body cam video and ruled that the Fourth Amendment was violated long before that dog ever sat down. The Fourth Amendment protects you from unreasonable searches and seizures. That protection doesn't disappear just because you're in a car, but courts have drawn some lines that can be confusing. One of those lines comes from Illinois versus Caballes, a 2005 U.S. Supreme Court case. The court held that during a lawful traffic stop, a dog's sniff around the outside of a vehicle is not a search under the Fourth Amendment. So if you're lawfully pulled over and an officer walks a dog around your car without extending the stop, there's no constitutional violation just from the dog sniff itself. Sounds simple, right? But here's where the trapdoor opens. In Rodriguez versus United States, decided 10 years later in 2015, the Supreme Court made something brutally clear. A traffic stop may not be prolonged beyond the time reasonably required to complete the mission of the stop, handling the ticket, checking the license, writing the warning, unless the officer has independent reasonable suspicion of another crime. If an officer holds you longer just to wait for a K9 unit, without that reasonable suspicion, the extension is unconstitutional. Everything that follows from that delay, including a dog alert and the search based on it, can be fruit of the poisonous tree. Now, rewind that dashcam footage. The warning was in the driver's hand. The traffic mission was over. The officer said, "Hang tight." 12 minutes go by. No reasonable suspicion of anything beyond the tag light was articulated on the recording. That's a textbook Rodriguez violation. The dog's alert may have been real, may have been perfectly trained. We'll talk about that in a moment's session. But it came after an unlawful detention. The evidence was suppressed, not because the dog was wrong, but because the officer held the driver without legal justification. So let me give you the exact words you need in this situation. And I want you to remember them because they create a record. If you are stopped and the officer issues a citation or warning and then tells you to wait for a dog, you say this. Calmly, looking straight ahead or toward the dash cam if it's running, "I do not consent to any search." Am I free to leave? That's it. Not argumentative, not loud, just clear. That single sentence does two powerful things. First, it explicitly revokes any claim of consent. Even if you never gave consent, making it unambiguous on the recording helps later. Second, it forces the officer to either let you go or articulate a reason you're being detained further. If they have no reasonable suspicion and still hold you, the clock on a Fourth Amendment violation starts ticking right on video. Now, what about the dog itself? A lot of people think that if a drug dog alerts, the search is automatically legal. That's not quite right, and Florida versus Harris from 2013 explains why. The Supreme Court held that a dog's alert can establish probable cause, but only if the dog is trained and certified and has been reliable in the field. The court rejected a strict checklist approach and said the question is whether, under the totality of the circumstances, a reasonably prudent person would believe the dog's alert indicates the presence of contraband. But here's what that means for you. The reliability of that specific dog can be challenged in court. If the dog has a history of false alerts, if training records are incomplete, or if the handler cued the dog unintentionally, the probable cause can collapse. I've cross-examined handlers about their maintenance training logs and watched cases crumble when it turned out the dog was alerting on the handler's body language, not actual odor. So on the body cam footage, you watch the dog approach the sedan. It circles once, pauses near the rear bumper, then rounds to the driver's door and sits. That sit is the alert. The handler says, "My dog just alerted," and suddenly doors are opened, pockets are emptied, and the search begins. But if that dog has a 40% false alert rate in controlled testing, something you'd never know, standing on the roadside, the probable cause that looked solid on video may be thinner than tissue paper. And if the stop was already unlawfully extended, none of that matters anyway. This is where the exact phrase you say before the dog ever arrives can completely change the outcome. The driver in our dashcam video didn't say those words. He sat silently, assuming he had no choice. And in a different jurisdiction, with a different judge, that silence could have been used to argue he acquiesced to the extended detention. Though legally that's weak, it happens. By speaking the words, "I do not consent to any search. Am I free to leave?" you are planting a flag on the timeline that a defense attorney can later point to and say, right there, at 23 First and 14 versus 05, my client asserted his right to leave. Everything after that is an unlawful seizure. Let me walk you through another scenario that shows why the distinction between consent and probable cause is everything. Suppose the stop is still active. The officer hasn't handed you the ticket yet, and he says, "Do you mind if I run my dog around the car?" You can say, "I do not consent to any search." He may still run the dog, because during an active stop, the police don't need consent to conduct a dog sniff outside the vehicle, so long as it doesn't add time. But again, your statement creates a record that you did not voluntarily cooperate. And if the sniff does prolong things even by a minute, you've preserved the Rodriguez argument. If you stay silent, the exact moment of delay can become fuzzy on the recording. Your voice removes the fuzz. There is another phrase people sometimes throw out: "I don't answer questions." That's fine for interrogation, but in a K9 situation, the more precise tool is the one I just gave you. "I do not consent to any search" directly addresses physical intrusion. "Am I free to leave?" challenges the seizure. Together, they cover both Fourth Amendment angles, the search and the seizure comp, and they fit perfectly into a short clip that a judge can replay. Now, I want to touch on something I see in body cam videos over and over: the handler's technique. A dog might alert because the handler unconsciously tightens the leash, changes pace, or pauses near a seam where they think drugs might be hidden. This is called handler cueing, and good defense attorneys have successfully excluded K9 alerts when the video showed the handler leading the dog to the spot. If you ever find yourself in a situation where a dog alerts and you end up charged, that body cam footage isn't just evidence against you. It's also evidence you can use to challenge the reliability of the alert. Watch the handler's hands, the leash tension, whether the dog was given an implicit search command. It sounds technical, but these details can win a motion to suppress. Let's step back to the dash cam. The 12-minute delay, the handler's smooth circle, the dog sitting dead center on the driver's door seam cammed. All of it looked impressive on the screen. But because that driver's attorney zeroed in on the delay and the lack of reasonable suspicions, none of the physical evidence made it past a suppression hearing. The case isn't just a legal curiosity. It's a template for how you should think about your own rights on the side of the road. So what do you actually do, step by step, if you're in this situation tonight? First, after the initial stop, provide your license, registration, and insurance. You don't have to chat. Second, if the officer says anything about waiting for a K9 after the ticket business is finished, I do not consent to any search. Am I free to leave? Third, if you are told you're not free to leave, don't physically resist. Don't argue. Don't raise your voice, just repeat. I do not consent to any search. Every time a door is opened or a bag is touched without your consent, those words on the recording are gold. Fourth, if the dog alerts and a search happens anyway, comply physically but never verbally agree. Fifth, as soon as you can, write down everything you remember about timing, how long you waited, what was said, whether the handler gave any cues. Those notes, plus the recording, are what a lawyer will use to fight for suppression. One more nuance that surprises a lot of people. The dog sniff itself is not considered a search of your car. But if an officer physically enters your vehicle, contact, even just opening the door to let the dog stick its nose inside to bound, that changes the analysis. Under the Fourth Amendment, opening your car door to facilitate the dog's entry is a physical intrusion that can require either consent, probable cause, or a warrant. If you've clearly stated, "I do not consent," and they open the door anyway without probable cause, that's an unlawful search unless some exception applies. And a dog alert from outside the car, if valid, can supply that probable cause. But if the alert happened after the stop was unlawfully extended, the probable cause is worthless. So the chain of logic goes: stop must end on time. If it doesn't, detention becomes illegal. The dog alert after illegal detention is tainted. Search based on that alert is suppressible. Evidence gone, case dismissed. That's the domino effect you saw in the dashcam case, and it's a direct application of Rodriguez versus United States, reinforced by the exclusionary rule. And now, before I wrap up, I want to give you one more piece of vocabulary that might end up in your toolkit. In some jurisdictions, the prosecution will try to argue that the dog sniff was an inventory search or a community caretaking function. Those are exceptions to the warrant requirement, but they don't let an officer prolong a completed traffic stop. A community caretaking function, like checking if a driver is having a medical emergency tailing, must be genuinely unrelated to criminal investigation. If the dashcam shows the officer was simply waiting for a drug dog, that's not caretaking, and a good defense attorney will swat that argument away quickly. So here's your takeaway phrase, the thing I want you to be able to recite without thinking. I do not consent to any search. Am I free to leave? Keep your voice calm. Let the dashcam and body cam capture it. And if you're ever sitting in a courtroom watching that video with your attorney, you'll be thankful those 10 words are on the record. Next time, we're going to talk about what happens when you're asked to step out of the car for field sobriety tests, and the surprising reason why the way you exit the vehicle can affect the entire case more than the tests themselves.